Hello, everyone. Thank you so much. I hope that you've enjoyed the sessions by Mr. Munish Sudan and Dr. H. Purushottam. They both talked about innovation at a very macro level, and it was incredible the examples that Dr. Purushottam gave regarding academic technology transfer. And there's so much help available to get your prior art searches done. Ask help from NRDC. So in this session, we it's a great natural extension, this session, for the talks that we just had, because we had talked on technology commercialization, on innovation in general, and now we are going to be talking about how as innovators you can think and transform your ideas into real businesses. So we have with us Miss Shuchi Agarrwal. She is the managing partner of IPNeeti. She has more than 20 years experience in the IPR domain. So she is one of India's leading lawyers, a leading patent attorney in India. And she has her company IPNeeti, which is based in Noida. And she has a very good understanding of the IPR ecosystem in India. So while she's instrumental in devising, various IP strategies for her clients, so she equally spends, time on providing end-to-end patent solutions for startups, for established businesses. So today with her, we will talk about transforming ideas into business opportunities. So I'm going to bring Shuchi ma'am on stage, and we will in due course share your presentation. So ma'am, the stage is yours. I will, be in the background. If you need anything, you can just ask me and I'll, come back live. And I'll also share your screen. So, at your cue, or if you just want to address without sharing your screen, that's also okay. So thank you. The stage is yours.
Thank you so much, Rahul. It's a pleasure to be part of this conference. Thank you for the great introduction that you gave me. And a very good afternoon to all of you who are listening us live. And I'm sure you've enjoyed various other sessions. Given that this is an expo and we're talking about a very, very vast subject like transforming ideas to business, I think it would be very, very natural of me to not try and delve too much into the theoretical aspects of it, but maybe just try and understand what do we keep talking about when we talk about ideas, business, IP, how do these things actually interplay with each other. So I've put together a few slides, just will share some thoughts that might be helpful. I encourage all of you, as and when, if you have any question, to please stop me then and there and ask your questions. I'll be happy to respond. Having said this, let me share the screen so that I can put across some of the slides. I hope the slides are visible now.
Yes, ma'am. It's okay. It's okay.
It's okay? Yeah. All right. Okay. So if I make it full screen, is that okay now? No. I think the moment I'm making it full screen, it's going off. Yes? Okay. So maybe I'm not going to make it full screen and not start the slideshow, but just put it individually, right? So the topic that we're dealing with here is transforming ideas and into business opportunities. Literally, what do we really mean by this? So of course, the buzzword that we're talking about here is an idea. An idea, because everything starts from the particular four-letter term IDEA, right? What does it really mean? And especially for the people who are hearing me live, the entire thrust on this four-letter word is because of the fact that we are talking about making some money or seeing some commercial gains by putting it to the right practice or the right way. So if I look at it, if I go by a traditional model, typically what will we end up with? We have a particular idea. Let's say we want to start a business, or we want to trade a particular product. We want to offer a completely breakthrough new product, etc. Whatever it is, this particular idea, the first thing that we'll check is whether this is feasible. So, we'll see whether this is something that can be worked in the market. Are there many people who are going to be interested in really looking at it, buying it, and then using it? Also, we also try and evaluate a lot of these success stories where we try and see whether this has a long-term reach in the market. Also, how easy is it for people to copy, isn't it? That's a very, very important parameter that most of the times plays in the mind of people. Now, while we do all of this, typically for us to be able to launch a particular business or put an idea to practice, there are two approaches, right? One, we talk about a conventional approach, and the second that we talk about is an unconventional approach. Why do I demarcate it into two forms? Largely because when I talk about a conventional approach, I am talking about where we are doing a lot of assessment studies of our idea. Now, those assessment studies will start with we need capital, right? We need something to set up the infrastructure, to have the right manpower in place, to do some sort of market survey, to have a particular strategy, as we love to call it, etc., etc. Essentially, everything and anything that goes in a particular traditional direction is what I would largely classify as conventional. Is that a wrong approach? Absolutely not. But this is something that is being tried and tested over a period of time and which mandates that you should have the right seed in place with the right capital so that you can get going, right? But what if we are stuck with something which is unconventional, which is a new idea? So you must be wondering why these funny bottles kept in front of you, right? They're unconventional, yes, of course they are. But that's exactly the point I'm trying to hit at. So if you have something which is an unconventional idea, think about it. How do you think or where do you think the design of these bottles started? Certainly in the mind of a human being, isn't it? Somebody who may have conceived at some point in time that they could make a bottle that may look very funny, that may look very, very different from the other existing bottles in the market, which largely can be tagged as unconventional. If you are the creator, what could be the first question in your mind when you design such a bottle? Would the question be, how could I take it to the market immediately and start making money? Or would the question be that this is such a differentiating bottle, if I put it in the market, how soon would it be possible for copycats, so to say, to just go ahead, copy this bottle and launch it in the market and possibly at a price which is very, very competitive and a fraction of what I'm offering, and therefore flood my market, destroy my market, and make gains for themselves? Largely, as an entrepreneur, that would be a big concern that will play your mind when you talk about launching something which is unconventional, something for which you're trying your best to make a niche, to make a mark in the particular market, and also at the same time, you want to do it in a little secured fashion where, if at all, there is somebody who takes a step which is against you, against your plans, against your rights, you should be able to stop that then and there. Is there a particular way of how you can stop an infringer's approach to something that is yours? Certainly, yes. And this is exactly the unconventional or untraditional route which is being offered when we talk about IPRs, which is, if you look at this particular bottle, what I would want to do if I am the creator of this particular design, how can I protect this design? If at all I can, what is it that I can protect in this design? Do I really see different elements that can have different parts to it, which essentially are going to make a big difference for me to run my business? And that's where you would need the help of an IP expert, or possibly, if given your own understanding of IPRs, you could come up or arrive to a certain point, you would weigh the following options, which is whether for the particular aesthetic part of it, which is the way the bottle appears, should you get a design registration in place so that anyone who makes an aesthetically similar bottle, you can stop them then and there, and actually not only stop them, but also get a share or also get damages from them, or share of profits that they've made from there. Should you look at anything which is technically different? Maybe the way how you make this particular bottle, the method of manufacturing this, maybe the way how you're sealing this particular bottle, if that is something that is very different, you might want to check that and see if you can get technology patents to secure the same. Then next, what we're talking about is there any artistic element? You 100% would be using some sort of labeling here to mention the product. If that is very creative and artistic, that could be something that you can check out if you can file for a copyright protection. Or 100% when we go ahead and we market, when we go and buy anything in the market, we generally check out the first thing, which is a brand name, isn't it? Most of the times, if not always. So the name that you tag for this bottle is something you will be wanting to protect by way of trademarks. Now, is that something that is very, very conventional in approach? And is this something that is tied up to your manufacturing setup, your infrastructure? Not really. While, of course, if you end up going the conventional way of manufacturing the bottles yourself, of putting it to the market yourself, marketing it yourself, still, if you have these four things, the classic part of IPRs is that you may be putting to use your patents, designs, copyright, trademarks yourself, but you also have the right to go ahead and license the same so that parallelly other people could go ahead and use the IP which is yours by way of taking a license from you, which means extra money for you. Or for people who are traditionally inventors and have a very inventive mindset, they could continue with their research, and just by having these IPRs in their name, they could start making money. There is a particular argument here. A lot of the times that I hear from inventors, a lot of the times while speaking to people in academics, I do hear this. It is absolutely true. Statistically, less than 5% of the patents which are filed are being commercialized. But largely, the fact that less patents are commercialized is that the entire fallback upon the legal system, that the legal system does not promote, or there isn't enough caveat to it, or is there something more beyond this? It is also very, very important to understand that if you have to market something, right, there is a particular marketing mindset that you need. People who are deep down in research and who have very inventive mindsets may not be the brightest minds when it comes to marketing the particular thing, right? And I think that mismatch plays a very, very big game in the long run, because largely inventors are deep down inventing into the technology part, into the designing part, into the creatives, and most often than not, they lack the business acumen of dealing with market dynamics and accordingly launching it. As an inventor, as a startup, as a person who is looking for some commercial benefit out of the idea in an unconventional way, it may not be a bad idea at all to also be a partner with, or to actually see if there's someone who can help you with the business part of it. Therefore, rather than just taking a particular patent or a design or a copyright and leaving it idle, you may be able to make a lot more money out of it and put to business use of it. In fact, if you look at it, out of the patents that are commercialized, large chunk of it is the one where the patents have been assigned to a business entity, which means patents which are being held by academics, by individual inventors, etc. They are not the ones which are largely commercialized in the commercialization figure that I talked about, but largely it is always the case where you have a commercial entity that has taken the rights and has then put to use by way of a license, by way of, let's say, we talk about manufacturing setup, etc., etc. In fact, one good example to just illustrate the point, yes, IBM is a big company, but if you look at it, ultimately 1.2 billion that I've tried to put here is, this is the amount that they have generated only by way of licensing their patents. We are not talking about any physical infrastructure. We are not talking about any kind of other capital required for setting up machineries, etc. But simply by way of licensing their rights to a third party who can thereafter use their patents in manufacturing the product or whatever, they've been able to generate this kind of money. As individuals, as academics, or as people who are part of small companies as well, or anyone for that matter, there is always a merit in finding if there is a market for you. In fact, you being the inventor is the best judge, because when you would have devised the particular solution or a new design or a new trademark or whatever it is, you would know what kind of problem existed, what have you tried to overcome, and if you are convinced about the solution that you're offering, it's always a good bargain to see if there is a business mindset that you can get along with you, who might be a big asset for you in the long run. So what are the traditional ways, etc.? So if I just take little more time trying to explain, just touch upon patents, trademarks, copyrights. Patents is one way of how you can transform your technical idea into a business feasibility. In fact, Sometimes, and this is a lot of the times when I deal with my clients of late, especially business of any level, whether a startup or established one, when they're looking for more opportunities and all, the first question that the VCs ask them is, do you have this particular thing protected by way of patents? We see scope, but unless we find that surety that we will be able to catch somebody who's copying this particular thing, we believe investing our money in this particular bargain is a lost case. So yes, patents can help you in a lot of your business decisions. They can get you money by way of licensing, by way of, if it is of no use, then by way of assignment, where you sell your patent, or for marketing gain for your stocks everywhere. You could use your intangible asset, which is your knowledge capital, in a big way in building a business out of it or transforming it to some sort of a business. Next question, and I think this is something a lot of the times people do ask me, is also very, very closely tied up. If you have come out with something, maybe a formula, maybe a composition, maybe a particular method of trading with something, the outright question is not really the fact whether you should go for a patent or a trade secret, but the outright question is, what really is your long-term goal? Is your long-term goal that you're going to be entering into a business? Are you going to be licensing this out and not be the person who is himself or herself driving the entire thing, manufacturing, setting it up? Or is it something that you think it's better to conceal it, understanding that the moment that this is out in the public, you lose all your particular rights? That's where you try and understand what is the best bargain for you, whether it's a trade secret or whether it is a patent. A brand creation is very, very important. In fact, I think a lot of the times when we go out to buy even of basics of our basic of our stuffs, the first thing that we check out is whether this is a good brand or not, right? So if you are trying to set a niche in your area, you should try and market yourself so that you are a big brand tomorrow. There are steps that you need to take. You 100% have an option of going for absolutely cost-effective solutions, but please try and always assess that sometimes being too cost-effective may also mean that you have in the bargain lost any and every right that you could have. So be very diligent about it. There are different steps involved, like pre-filing analysis, and now no more trademark is something that is limited only to the trademark law. While doing pre-filing analysis, there are a lot of other factors that you should take into account: your domain names, your unique trademark availability, etc., going up to the prosecution part till building a particular brand. If you're someone who has an idea that relates to a software, the natural question for you is, how is it that you should have all aspects of your business protected and also at the same time take incentives or make money out of those? So there are 3-4 particular aspects that every software is involved with, which is patent, copyright, trade secret, and designs. You should try out and get every particular aspect of it covered and see, maybe because at any given point in time, it is not really required for you to make money that all 4 streams of or all 4 aspects of the software being licensed out. Sometimes maybe simply licensing a patent, or maybe simply licensing a copyright, or maybe just the design, which is a particular important UI, which is linked to your particular solution, is also a good game for you to play with. My honest advice to all of you is, you should trust and nurture your knowledge capital. You never know when only and only your knowledge capital can become very, very handy for you, help you transform a lot of what you've created into wealth. I'm not even talking about just making money, but it could result. In fact, there are a lot of cases that I can talk about. There are people who are as inventors who have about 38, 40 patents, who, by taking the right steps in getting protection of those patents in India and in US, today by simply licensing those out and keeping a tight eye on infringers, they have made a very good living out of it, and they are continuing with their inventive spree. Similarly, if I talk about, there are ways of how even academics are promoting of late their options of seeing how they can use their patent portfolio, because academics having specialization in generating and disseminating knowledge, they're now open and they've started partnering with people who can take a technology transfer from them and make actually viable products which can then use their knowledge capital of patents, etc., and be put to business use. I really think that whatever knowledge capital we have, uh, it could be a good gyan for us. But if we can also find a business solution, a great product that solves a great problem existing in the market, 100% there is a bet that you could have a market out there if you try it out in the right direction. With that, I open the floor for questions.
Thank you so much, ma'am. Thank you so much. Really interesting, because of course the business part is often overlooked when academics are talking the about IP, because it's a black box for them. Patents are
Absolutely.
meant to be filed, but the future is not known. So
Absolutely.
so
It's more
folks,
like a cost intensive stuff. The way it is being judged at मुझे
right.
50,000 रुपए खर्च करने पड़ेंगे मुझे 1 लाख without really seeing if that is being done or if that investment is being made. There is large possibility of you can recoup. In fact, if I talk about one of the client that I'm right now working with, the person was working with one of the biggest MNCs, quit the job, and maybe because the person had the drive, he made a very simple daily use medical product. While we are still in the stages of getting this up by way of getting design and patent protection to the person for the particular inventions they've done and the ideas they created, they already have two people who have asked for license from them. And you know what? The amazing part of it is that the licensing, which you can do, is not something like it is just one license issued and gone. You could have different checks and balances, you have different strategies because you yourself are going to be launching it, exploring it, etc. So imagine somebody who is any which ways was not launched even a particular product, but by way of the fact that he has protected designs and patents, has started marketing, he already has two people who have shown interest, two good
Mhm.
companies who have shown interest in taking a license from him.
Mhm. Can
So
you
just
elaborate on the marketing part? Like, how can, say, someone market something that they have? Maybe it's not even a patent filed yet, but maybe they can market it to get
that's
funding
a good
or.
question. Right. So if you don't have a patent filed, an application filed as yet, my sincere advice is do not market.
Hmm.
Because the law says that you have to first submit an application before the patent office to secure your priority, and only once you
Mhm.
do that can you go ahead and start marketing. Even if you file a provisional application, that's good enough because
Provisional,
your
yeah.
priority, yes, your priority date is established, right? Thereafter you can start all your marketing activities. Now,
Mhm.
once you have the marketing part ready, right? You have the patent application pending. You could customize it because marketing generally, as much as I can talk about or I have seen, it never requires that you have to share nitty-gritty details of everything, right? Marketing
Mhm.
is an activity or an act which is focused more on getting attraction from your customer, your potential
Mhm.
customers, to convince them in a fashion that yes, the product or a service that they buy, it has a merit and it solves an actual problem of an existing problem for them.
Mhm.
So I think marketing materials, while yes, they can be sometimes a big disaster if not very well sketched out, but largely if they're being done in the correct direction, they also incite a lot of interest in your potential customers. And then imagine for yourself, if let's say if I am going out and buying something and I see a particular tag out there, patent pending or design registered, etc., it naturally gives a boost to the marketing because this means it is not only something that is being certified by the individual who's offering me that, but there is also an agency which is a government agency which is the one that is doing it. I think Madhuri has put up a question here.
Yes, yes,
What
yes. It kind of leads to it, maybe.
Yeah, possibly. So I read the question posted by Madhuri. What precautions should be taken while licensing out your innovation to somebody else? In fact, Madhuri, that's a very good question. In fact, there is no particular, I would say, criteria that ABC should be followed. One, it is something that is case to case basis. The most important thing that I think you should consider while you license out your technology is whether you want to let go of your technology license completely to somebody, or do you want to have a right that you could have multiple people who you can license the technology to. So that's basically a decision that you take between an exclusive and a non-exclusive license, right? Other than that, what you really look out for is there a particular term duration that you want to explore, whether you want to give a license for the remaining term of your patent or a design or whatever IP right, or do you want to restrict it by a particular number of years? Do you see a market which is more in a particular area, let's say in the northern part of the country, southern part of the country? So largely it is your interest, your terms that you would want to be followed, and what is it that you can follow thereafter. But my recommendation to my clients largely is, if there is a possibility and if they see that they have excitement or they have interest from multiple people who might be wanting to take forward their inventions, they should always go for non-exclusive. For example, if you look at it, you have these classic chains, if you talk about McDonald's and all, where it is not really the person who is the holder of the trademark, be the person who is giving a license only to one person, but these are franchisees, right? So licensing depends a lot on the area, on the terms that you want, the type of license you want to offer, the term duration that you want, whether you would want it per product basis, whether you would want a particular lump sum payment, etc. Okay, I have another question from Jyoti. What's the difference between copyright and patent? Perfect. Okay, so I think the best way of giving an answer to this is an example, right? I just wanted to be very simply put in a manner where you should be able to differentiate for yourself, if I'm able to put across the point very well. So, how many of you have actually read books? A lot of you, right? If not novels, for sure in your schools, right? So that is something, if I talk in IP language, it is a literary work, right? Something that is being written. So a creation which is by way of your mind, which is in a written form, is literary work. Copyright is basically an IP right, which is given to a literary work, maybe an artistic creation. An artistic creation would be like lyrics of a song. It could be for music compositions, it could be for sculpture, etc. So largely the categories are artistic as well as literary. But if you talk about the patent part of it, so patent is for the technology, which is the function that you're talking about. Classic case that can help differentiate between the two, if I talk about a software. So whenever we talk about software, we are talking about two aspects to it. There is a particular code that is written in a programming language, right? That could be any programming language. The literary part, which is the written code, which you call as a source code, is the subject matter for copyright, as that is a literary work. However, once you execute or you implement that software on a machine, there is a particular function it performs, right? And that function is what you are able to protect by way of a patent. So, in a gist, patent is something that is more for functionality, which helps you protect the technical part of your creation, and copyright is more artistic or literary protection to your work. I have another question which is from Santosh, and I read out: can I patent and commercialize an IoT product built using open or free sources? Okay, so the very fact that you've used a technology which is an open and free source, you would understand, and I'm sure you would appreciate, that there is a particular license that is being involved whenever you access or you use any open source work, right? To the extent you are directly, and this will vary on the basis of case to case basis as to what real open source license is of the code, of the technology, or whatever you have taken. And the licenses are fairly detailed. They clearly identify what part of it can you, if you develop further, can you have a patent on it, and what is it that you cannot, right? So you should, number one, read the terms and conditions which are provided in those licenses. Most of the licenses, and I'm not saying every license for it, but most of the licenses do allow you that if you build upon an open source technology, then there is a particular part that, which is of your own creation, you can protect it by way of a patent. And because if it is a patent that you've protected on your own, you will be able to commercialize. And what is it that you cannot protect by way of a patent and commercialize? So I think this will depend on two things. One, what the terms and conditions of the license are. And second, what is the extent of modification that you've made to that open source work, for which whether you would be liable for a patent or not, and accordingly commercialize. Another question is from Balagopi. What is the importance of an NDA agreement? This is such a beautiful question. Thank you for asking this, Bala. So first, let's understand what is an NDA agreement. If I talk about simple full form of it, it's a non-disclosure agreement, right? Which basically means that if you were to discuss with me your invention as a patent attorney, because let's say you're interested in filing a patent for the invention that you want to discuss, before you do that, you want to be doubly sure that I am not going to leak this invention to any of my other clients who might take the benefit of taking over this idea, maybe developing it a little more and taking it away. In fact, I can give you a classic case of really how important can an NDA be. This is one of the cases I had dealt earlier on in my career. There is a university which I'm sure a lot of you would have heard about, is a Punjab University. Once upon a time, I was dealing with a particular case where a entire team, so the professor and his students had approached for getting a particular patent for a new invention that they had generated. While we were working upon this, there were certain things that needed to be checked. And of course, there were certain researches to be done, which is basically a patentability assessment, as we call it. And then the professor came back and said, look, we're just working on it. Give us a couple more months, and we are going to send you a refined version of it, which was absolutely the case, a classic thing. While we were waiting and he came back after a couple of months and we did the patentability assessment, we found that there was a publication of another patent. There was something out there which was very, very similar. So naturally, we shared the same with the guy and with the professor, just to tell him that, look, this is already available, etc. The professor was shocked, and he was shocked beyond his imagination. The reason, what he had done was already leaked out by his team to a friend who had in turn gone ahead and filed a patent in his or her name. The problem here is that there was no NDA that you could have stood by to this third person who got to know the idea. Well, of course, this is passing of information, but why this sets up a precedent? Had there been an NDA, number one, there was a possibility that you could come back and use that as a contractual right to save yourself that this guy did not abide by the contractual term that was being taken care of. But given this was not there and the first disclosure was already made of the invention of someone else by a third party, now what you could rely upon is later on at some stage whether you want to go ahead and get into a false inventorship claim or obtaining the invention by fraud. So as a bottom line, an NDA secures you from any kind of unauthorized access to your information of the invention and give you a legal right to basically take this person up before the court of law so that you can at least get some dues back and you can use that to counter the requirement which is out there in the patent law saying that, look, I did my duty of getting the NDA signed. Still, if the guy went ahead and had done it, it establishes that I'm the prior person, I'm the first person who had taken this up, who is the inventor essentially. Another question is from Mrs. R. Renuka. Can lab manuals be copyrighted? Lab manuals can be copyrighted. However, we need to understand by copywriting a lab manual, essentially, is there anything that you want to achieve? If the purpose of having a lab manual is to establish a priority for your patent, then I think having a lab manual, which is duly maintained, along with the signature of who the invigilator, etc., is there, that is something that is very, very helpful at a later point in time to establish your priority, etc. But yes, if you think as a literary work, you would want to protect that, which you want to publish later on, you could go ahead with. Another question is from Sukhvinder Sharma. What is the role of applicant and inventor in granted patent for making licensing deal and profit sharing? That's a great question. In fact, a couple of things that we are right now, a couple of projects that we're working on is exactly in this particular area. So first, I think it's important to understand who is an inventor and who is an applicant when it comes to a particular patent application, right? So when you talk about inventor, we are talking about, as per the law, human beings or individuals who are the ones behind the creation of the invention, right? Because if I am creating a new kind of let's say, interface, or I am creating a new touch screen for a mobile phone, it is of course the mind or the intellect of a human being who has done that. The human being behind the particular creation is behind the technology, the invention is the inventor. An applicant by law can be an inventor or a company, but essentially an applicant is the one who commercially exploits and takes the benefit of the patent. That is the reason why we have these two separate sections in a patent application. Having said that, once you have a patent granted and you want to license it, now whether an inventor will be getting the benefit out of it or an applicant, largely because applicant is the one who is the commercial benefiter of this, is the person who will get the commercial benefit out of it. But there is always a provision, if I talk about like in India and all, the natural benefit, the commercial benefit goes to the applicant, but there could always be an agreement between the applicants and the inventors that once the patent is being granted and there is a particular money that flows out of that particular deal, then the money is going to be split between the applicant and the inventor in the specified proportion. So if you have an agreement in place between the applicant and inventors, yes, it is possible that you can have a split between the two. But if there is no agreement, then automatically in a lot of the countries, including India, the entire commercial share is of the applicant. However, if you look at, for example, China, there automatically there is a split between the two because the law mandates. If I talk about in India, the commercial benefit, unless there is an agreement to the contrary, is with the applicant. My next question is from Santosh. Can I apply my song lyrics for copyright but already published on social media? 100% you can go ahead and apply because copyright does not have the bar like in patents that you cannot disclose prior to your publication. The only thing is that if you've published it on social media, you would anyways have the date you would have established when did you publish, and you can claim that your creation, your work was effective or was created as on the date that you published on social media, unless you have a proof of a prior date when you created it. In fact, just as a suggestion, I can extend this that a lot of the times while we are doing a lot of work in progress kind of an approach, and if there is a content which is literary or maybe a song composition or whatever, if we can set a trail that establishes the time and date stamp, as an example, emailing the work to ourselves is also good enough in setting the date of creation of the work. You may want to try that as well. Next question is from Yogesh Kardam. Can a business idea be protected? If yes, how? Unfortunately, there is nothing called protection to a business idea. The business idea 100% has to have a shape to it, right? Now, whether your idea relates to a particular technology that you're trying to create and you're still in the stages of creation, then you can go for a provisional application. If your business idea relates to something which is more artistic in nature, which is something more design oriented, you could go for a design application. But per se, if I talk about that I have an idea of selling products online by building, let's say, an e-commerce portal, is that something that I could protect? That is not possible. So an idea itself, unless it has taken a particular shape or form in a particular manner and falls under one of the forms of IPR, under IP it cannot be. Sorry, I have next question from Kirti Suresh Babu. If our idea available as thesis and no one yet published such idea, which we plan to patent, so we have any chance to go for patent application? Yes, of course. So let me clarify. There are two things that I'm assuming when I say yes. That no one has published that idea, and even you, while you've done your thesis, you've still not published your thesis. So whatever your research is, whatever your technology is in that particular thesis, you have it with you. It is still not in public domain. And before you make it public, you should go ahead and file a patent application to the same.
Yeah, we are seeing a lot of nice session, good comments. So actually, ma'am, I also have one or two questions. So we were talking about the marketing
Thank you.
part, right?
Just 1 second. Thank you so much, please, Kanan.
Yeah,
I
yeah,
appreciate your comment.
yeah. There's few more. I'll maybe highlight it. And so yeah, I was asking that suppose I am an inventor with a patent filed, and now I have to market it. So is there a set of rules, or is there a set of a playbook which with which I can start this activity of marketing?
You are a person who has a patent in your name and you want to market it, right?
Yes. So now it's for me to license. So I'm an inventor, academic inventor, not say an entrepreneur. So what can I do like in terms of tangible
Okay.
things in marketing?
Right. I think marketing shouldn't be your first step,
Hmm.
honestly. Being someone who has a very technical mindset and a technical bent, first and the foremost, what you've protected as a patent, the technology, you should see if you have actually converted that to a particular product, which is a marketable product, for which there is a particular need in the market, right? A
Hmm.
lot of the times you'll be surprised that the inventors are so hardcore in the technology that they're so unconcerned and unrelated with the business requirements, right? And how do
Hmm.
you approach about the entire thing? So while because a mother of a child will always feel the child is the best, right? It's the same thing. The inventors feel that there's nothing like the invention they have created.
Hmm.
So they need to first see the realistic transformation of their patent, of their technology. If they see that there is really a problem or if there is a need that they can drive up to, then they should see if they themselves are convinced that they have that business acumen to take it to the next level. Otherwise, always have somebody who can help you in the business aspects, partner with that person, and thereafter draw out a map of
Right.
how you can create a need in the market. What are the right steps that you can take to launch the particular thing? What is the best time? Are there any other competitive products that you should position it again? How can you take best advantage of the fact that it is an IP born product as opposed to other products which are there in the market, which may not have an IP symbol to it, right? So there are different things that you can take and thereafter go ahead with it. You should as an inventor, because inventors are very well connected in the academic community, and sometimes also with a lot of the companies by way of their fellow friends, etc. If they already know competitor companies who may be of any interest, they might also, while they're trying their own marketing efforts, reach out to them. The hardest thing for an inventor is to pick up a phone and say, "Hello, I'm really looking out for partners for my technology," because they feel I can do it. Why should I go and ask someone? There is no harm in reaching out to a competitor of yours and see if they are interested in taking a license. You never know. You may be surprised that while you're looking for capital, you already have existing capital by way of license, which
Right.
you can then use for your own.
Okay. Okay. Interesting. Really. I mean, yeah. From some more comments, like really, thank you. And I really think
Thank you
some
so
of the
much,
insights you
Vaskirti.
shared is so precise that people. I mean, nobody knows
Thank you,
it from
Revati.
that much depth. So one more question I have is regarding copyright commercialization. So now, because everyone is a creator, right? Even like I'm a content creator for the last 6 8 months. So I'm making not just videos, but say courses, blogs. So what are the commercialization opportunities in terms of licensing and copyright? Like how are copyrights commercialized if I'm not something like T series, or someone like an inventor, an academic professor, or an academic inventor, or a digital content creator? What are the different things they can do for copyright commercialization?
Sure. So first and the foremost, I am not a copyright expert. So while I don't really deal much about copyright licensing and commercialization, but I can talk a little bit about from what little knowledge I have about copyright.
Mhm.
So what you're talking about is licensing of a literary work or commercialization opportunities of literary work, right? So typically, as much as my understanding goes, in academics area, especially when you're talking about course curriculum or books related to that. Now, the books could also be of different things. They could be for the subject matter, the content which is there. It could be about any questions and answers, because a lot of the times you see that people come up with these key guides, which basically have questions and the answers framed to it, etc. The most traditional and the most acceptable way is one where you can reach out to publishers and see if they have any interest in publishing those books. And then,
Mhm.
if you are a big face, you understand that's how the copyright industry works. You have bigger revenues flowing your way. If you are a new face, then relatively it's less. But I also see a lot of offbeat thing, and I think largely because of this information technology revolution, people
Mhm.
have their own websites that they have. They are trying to get more online coverage and presence where people can have subscription. They have apps where they've posted their content,
Mhm.
or they have cross licensed to their to various platforms which might be open in taking the courseware, provided they're
Mhm.
convinced this is something that adds to the value. So I think mostly now of late, online circulation, online licensing is what is taking more forms, and I see more requests in that direction as well, um, over the traditional methods. And I
Right.
think, yes, COVID kind of a situation has really put that up all the more, where people understand the limitations of offline curriculum, where you did not have access to books, children could not go to the school, but everything thrived only because of the fact that everything was available online.
Right. Right. We have a question, Amita Agarwal.
Sure.
Can there be two
Can
applicants? I-
Yes, 100%. I assume you're talking about the patent application. There is no bar on the number of inventors or an applicants in an application. There could be multiple applicants. In fact, if there are two applicants to a patent application, each of the applicants have the rights as if they are the sole applicants, except for the fact that if you want to sell it, then one applicant cannot sell the patent without the permission of the other. Otherwise, for all other activities, you can act as sole applicants to a patent application. And this I'm talking about is in India.
Right. Right. By the way, viewers, Shuchi ma'am will be there tomorrow too in a panel discussion on boosting IP filing in academia. So we can, do a maybe small preview of that session. And so what you will learn over there is a lot about some tangible things and success stories in academic, IP filing, so that you can, take home and probably get successful in the future with your own patent. So my one question regarding that, I will
Hmm.
be more precise tomorrow regarding this question, but something
Sure.
like say inventors sometimes have to put in their own money to file a patent. Say
Right.
there's two three inventors, they dutch the money and then they file a patent. So
Right.
what
Absolutely.
incentives, is there any incentives that can make them do this, so that that they're not scared to spend their own money? Or can they knock on some doors where they can probably get compensation, or some kind of a incentive to trust filings coming from individual inventors taking risk?
Right. And I think that's a very sensitive topic because a lot of the times when even I see individuals approaching me, they are quite reluctant. Not reluctant because they don't want to spend money, but because there is this always a question mark whether what I'm going to spend, is that a dead investment for me, or is that something that's going to reap some benefit for me, right?
Mhm.
So the first question to this particular question is, as a response, when there are multiple people who are as individuals wanting to invest, are they doing it because they believe that there is something that they've created which is new and they do not know what is the next step, or because they've really worked a solution which is for the problem they had themselves faced or somebody had suggested, and therefore as a byproduct what they've invented was an outcome which is now having a utility in the market. There is an application in the market, number one.
Mhm.
So if it is the second case where they are very clear cut convinced that they found a solution which is a workable solution, and that the next step is how open are they in going ahead and marketing it? Do they have any business insights? Does even one of them understand the business dynamics? And do they have channel partners from where, let's say, they can get it manufactured or take more insights and get the final product to the market? I think this is the safest route to go ahead with. Decide what the product is, what is the problem being solved, get the product up, and through the channel partners, see where you can market or license, right? By way of other people who might be interested. But if it is
Mhm.
something where they have come up with a technology which they came up because they were researching, or they found that this was something interesting, I think for them an immediate answer whether they will be able to get money is not that easy, because at the end of the day, for you to be able to make money, the funda is very, very simple. You need to be able to sell that in the market, whether you do it yourself or you have someone else selling it for you. Ultimately, only if it is being sold in a particular market would the money come back, right? So if it is not something that is directly worthy of an end product or an end service,
Mhm.
you will have to give it that particular form and shape, so that whether you or somebody who takes a license from you, or who buys the product or buys the patent from you, is able to generate. Because even for me to be able to take or buy a patent from you, let's say Rahul, I need to understand what is it that I'm buying. What are my business opportunities that I see from the work that you have created? And if I do see that, 100% I'm going to go ahead and take it to the market.
Mhm. Okay, we have a question actually, Pallavi Bhatia.
Sure.
Uh,
Hi, Pallavi. So the question
Defensive
that
correlation.
Pallavi, yeah. So could you suggest some strategies in patent system like defensive publication? Okay. So number one, largely if I talk about defensive publication is a mechanism which is vastly being exploited in the US patent system. Not so much so in India, I would say. But a defensive publication is something where, let's say, I have come up with a particular invention, and I know that this is not something that can be easily patented, and I want to make sure that I don't want to be sued by somebody tomorrow by obtaining a patent related to that, etc. So what I do is I post or I make a publication in a journal or whatever, which will make sure that I have made the technology or that particular feature, the technical feature, public. So then tomorrow, if somebody is going to at a later date in time file a particular application, this defensive publication will be used as a prior art, and that person will not be given the patent to the same. Another question from Sukhvinder Sharma. If there are multiple applicants, what is the role of name, position, profit share? Depends on position. Do we need consent from all applicants to make deal? Okay, great. So when you have multiple applicants, number one, there is nothing like a role that this is the first applicant, the second applicant, or the third applicant. All applicants are equal. Like I just said, that they are all treated as sole applicants. So let me elaborate what I just said by way of an example. Let's say, Sukhvinder, you and I are co-applicants on a particular application, on a particular patent. Tomorrow, by your efforts, you find somebody who can take a license for your patent. In that particular case, you can go ahead and license the patent without even having to worry whether you have to share a particular percentage with me, unless you have a contractual agreement with me, because you are treated as a sole applicant for that. However, if I want to sell the patent tomorrow, then I cannot sell it till I get your permission, your consent, and then whether I have to split the money with you or not is the understanding that we share with each other. So, some of the things, as much as they are clarified in the patent law, are also important to be understood, have a contractual aspect to it. Like in this case, if there is a prior contract between the two applicants that none of the two can get into a license unless they share the profit or they split this, or unless if they are getting into a manufacturing deal, they share the profits, nobody is going to stop you from alone exploiting the invention. The only case is the selling of the patent, which requires consent of all the applicants. Okay, so I have another question from Param Shivam. Can we commercialize when patent is pending? If so, what will happen if patent is not granted? Okay, so can you commercialize while patent is pending? Yes, you can. Though there is no instrument, there is nothing that you can call as a license agreement while the patent is pending, because these are provisional rights. These are not actual rights that you have till a patent is being granted. So you can get into a technology transfer agreement with the other party while your application, excuse me, while your application is being examined by the patent office. Having said that, there is no stopping to a normal licensing agreement. Uh, Now, if so, what will happen if the patent is not granted? Largely, if you actually end up being in a contractual relationship with someone who is expressing interest in taking a technology transfer from you, these kinds of clauses will always be there in those agreements that you might decide upon. As one example, that you are going to be paying X amount as lump sum, you're going to be getting royalty as X amount for a period till the time patent is being pending. As soon as the patent is granted, the royalty is going to change to X level, or that if the patent is rejected, in that case, you can reduce the lump sum or the royalty, whatever it is, or that the patent thing will end. So it depends what contractually you guys have agreed to. But if I talk about a very open situation, if there is a patent in my name and you have taken a license from me, which is a technology transfer agreement you've gotten with me, and if my patent is rejected, largely unless there is something which is a trade secret that we are bind with each other, you wouldn't want to continue with the patent and with the agreement, because you wouldn't want to pay money for something that is now in public domain. Every patent is published, please do understand. Vandana Gambhir, what are the checks and balances required for non-exclusive license to multiple companies? Vandana, this is a great question, but this is a fairly elaborate question. This needs a lot of time and a lot of cases because there is no one-size-fit-all approach to this. But a non-exclusive license, I'm sure you would be appreciating, is something where you can give license to individual companies or individual parties so that they can all parallelly use the particular technology that is yours. Are there any checks and balances? Certainly, yes. If I talk about some which are mainly important, the term should be there. The jurisdiction, the term in terms of duration, the conditions set out for usage should be there. The if there is any kind of trade secret element also involved to it, there should be strict checkouts on what checks and balances you've put here, that if they don't comply with their liabilities, with their responsibilities, what tomorrow is going to be an outcome and how is it that they have to pay back to you, etc. So this will depend a lot on whether the technology that you are licensing is only a patent protected technology. It has more angles to it, including trade secrets, including some other literary works or whatever, a computer program to it. And I think accordingly you can define what those are. But your liabilities, your checks, your different combinations about how the technology is going to be put to use, who's going to be manufacturing, whether they have a right to outsource, etc. All of those things should be very, very meticulously handled. Bala Gopi, already product is commercialized. Now, can I now patent it? I'm sorry, Bala. Because your patent is commercialized, your product is commercialized, that means it's out there in the market. And the patent law is absolutely clear that you cannot file a patent for a technology or for an invention which is out in public. So the product is in public. It's too late for you to understand if you can file a patent. However, if you develop any new improvements to that particular product, which are something which are only with you or your employees, and my assumption is you would have an NDA with your employees, you could see if you can protect the same by way of a patent, the improvements. Amita Agarwal, what is the difference between patent published and granted? Okay. So every patent application that is being that you file before the patent office, in normal course of duration after 18 months, the patent office publishes the application in a journal which they call is their patent gazette, and the details of who the applicant is and other bibliographic details with the abstract and all are published so that people can see the particular technology which is available out there. Which is also a placeholder to tell people that this is now next going to be examined by the patent office, and the patent office is going to come to a decision of whether to grant or reject it. A granted patent is the patent which has matured, which has been examined by the patent office and has finally received the seal and stamp of the patent office saying that yes, your rights are now with you, you have a granted patent. And from the day of your grant, you are given the rights as per the rights given in the patent law, where you can initiate an infringement suit against someone who is copying your technology without your permission. So there is a difference between publication and a grant.
Thank you so much. Thank you so much, ma'am. This is fascinating, really, to get some insights. And actually, to the audience who's watching, ma'am is going to have two more sessions tomorrow. One is the panel discussion I just mentioned, and the other would be hits and misses in the IP playground, which are going to be compelling case studies that, as academicians, as inventors, you would be, better off to know. Sure. Yes, ma'am.
Right. Just one point that I'd like to add in my session, especially which is about hits and misses. I'm not going to talk about any theory. I'm going to talk about exact examples of companies and individuals who the kind of mistakes they've made, which have led to loss of their revenues, or the right practices they've followed, which have helped them in getting proportional benefits out of it. So, any one of you, if you're interested, because I see a lot of practical aspect questions coming up here, I'm sure you would benefit in case if you have time and you would like to attend the same. Thank you. And I really appreciate the audience. It's great audience. The amazing questions, in fact, across the spectrum. And I hope I've been able to just contribute my 2 cents for your knowledge.
Thank you so much, ma'am. Really appreciate
My
your time,
pleasure.
and we will look forward to see you tomorrow.
Thank you so much. Thank you so much, everyone who was listening live. Thank you once again.
Thank you. Thank you. So, folks, this is a public stream that will keep running throughout lunch. So, as you know, we are now going to have a lunch break, 1 to 2 p.m. But the stream is going to keep running, and I'm going to interact with you for 30 to 45 minutes. Just, for 10 minutes, I'm going to be gone for lunch. And during the stream, we will show you what you are in for in the next half of the day, and also what you are in for tomorrow. So, by the way, after lunch, we have some very good sessions on technology transfer. So, ITTO, India's largest technology transfer office, basically from IIT Delhi, they are holding 3 sessions, 4 sessions at Turnip Innovation Festival. So, after lunch, you can join those sessions. Actually, Miss Rima Sani, she is actually already mentioning in the comments. And you can also win gift hampers and Amazon vouchers when you attend those sessions. So they have real experience with academic technology transfer. And I suggest that for all your questions, keep your questions ready. Really, they are a gold mine of information that you might get for your academic IP and commercialization. So I really thank you, all the people in the audience, for showing up and asking these questions. So we are going to break for lunch now, but the stream is going to keep running. So if you are around, just feel free to write your comments, and every now and then when I see them, I will interact with you. And meanwhile, I will show you what we are in for in the next half of the session. So thank you. See you after a while. Bye bye. If you have any questions, please feel free to ask. I am actually going to share my screen and show you the event schedule so that, yeah, I think you can now see the event schedule. I will make the background so that everything's visible. So just after the lunch, we have a session by Questel India, and it is on patent prior art search and how to search for business opportunities, business potential with your idea. So Questel Orbit is actually the world leading patent search platform. So make sure Miss Kavita Poddar, she's senior director of Questel India, and she will what you're going to learn from here, it's going to be priceless. So please attend this session actually. So remember that the session link for the upcoming sessions is different. It's not the same as the one that you are right now, because this session, this live stream is going to end at 2 p.m. So this is a lunch stream. So it's not like there's no sessions going on, but so yeah, there is actually a comment which my team has put. So you can see Questel India starts at 2 p.m. and this is the link. So you should follow this link, keep it open in a separate Google Chrome tab, and at 2 p.m. this link is going to go live. So make sure that you are there for the, and also you would have got emails regarding the with the links. So can I ask in the chat how many of you here are have registered for full access? Balagopi, okay, yeah, it is. I will take it as thank you. So let's see today's sessions. If you have any questions, please write it on the chat. So today, after lunch, you can see we have 2 sessions, both starting at 2 p.m. So for full access users, we have Secrets of Claim Writing by Mr. Tapan Brahma. And this session, folks, is going to be again very, very interesting and insightful. So patent claims is really a black box. And Tapan Brahma, sir, he has 20 years experience in global patent filing and litigation. So his knowledge of claims is so precise that I think that it will, for a very long time, you will, value the information that he will give you. So this is only for paid participants, for the full access participants. So if you are still considering, there's a link in the description. So there's a link in the description, and for the full access, it's 249 rupees. And I'll just highlight it. So there's a link in the description with which you will get access to all 20 live streams, and you will also get all the recordings, and including all the private ones. So make sure that to make the most, interact with Tapan sir, and interact with even after Tapan sir, we have a very, very interesting session on copyrights. So you can see here, deep dive into copyrights, part 1 and part 2. Basically, part 1 is today, part 2 is tomorrow. So both days, 3 p.m., 3 to 4 p.m. And these will be conducted by Miss Shravani Deshmukh and Miss Yashashwini Oja from CPIP Partners. So they have conducted sessions with us in the past, and I can tell you about how interesting, insightful session they are going to have on copyrights, and it will be quite detailed. So even if you are a beginner, you would start from scratch, and you would get a really good understanding of what copyrights are, what they do, what are the nuances, what are the cases. And they also have a small quiz. They also have some questions for you that you can answer. By the way, for people who have attended, who are not fully registered, I'll tell you that we are giving out 10 Amazon vouchers of 500 rupees each. Okay. And all you have to do to win those vouchers is to use the TIF 2021 hashtag and tag us on social media on whatever you learned from Turnip Innovation Festival. So if, say, Mr. Munish Sudan said something interesting, you put it as a quote. use it as a note making tool. Use Twitter and LinkedIn as a note making tool. Make sure that all your posts are tagging us. So on LinkedIn, you have to tag us on the Turnip Innovations page, and on Twitter, you have to tag us with @turnipinno. So I'll give you the posts. So @turnipinno would be how it looks like on Twitter. So actually, I have to put it maybe on here. And you have to put the hashtag like TIF 2021. So that's all. That's all you need to do. And after the event, we will look at who has made the most engaging posts, and who has made, who has articulated in the best possible way the learnings from TIF 2021. So folks, I suggest that if you are a full access, participant, use your social media, get the word flowing, and we will look at all the tweets, all the LinkedIn. Hello, I hope that you can still hear me. So yeah, I was saying about the Amazon vouchers that we will give out. So please register, and I already said in the link in the YouTube description, there's a link. You can go to the event page and you just click on register and register. And let me show you more about the festival, about what you are in for. If you register now, what you are in for tomorrow. So we have also session by Miss Pragati Agarwal today at from 4 to 5 p.m. So ITTO, like I already said, it's India's largest technology transfer office, and it's inside FITT IIT Delhi. So they really know about a thing or two about academic technology transfer. They have also their own conference goodies and vouchers that you can win, and they have everything that as an academician you need. For example, funding, what kind of funding calls there are. Even they themselves have their own registration form where you can put your idea, and they have startup support and registration. So from 3 to 4 p.m. Today, also Miss Sanskriti Pawan, she will talk about the BIRAC big ignition, the biotechnology ignition grant. So the big BIRAC grant. So that is also one very interesting thing. So if you're in the field of biotechnology, there's a host of funding opportunities. So I suggest folks that you don't miss out on these sessions. If you're a free participant, then also you can attend this talk from 3 to 4 p.m. But you will have to register via the free link. So there's also a free link on the website, on the YouTube description, which you can click, and that's it. Yeah. YouTube description. So yeah, I see a comment. Let's see. Rima Saini, thank you at Turnip. Yes. So Miss Rima Saini, she is from ITTO, FITT, IIT Delhi, and make sure you attend the sessions from 3 to 4 p.m. by Sanskriti Pawan and Shubhradeep Basak, and 4 to 5 p.m. by Pragati Agarwal. And also tomorrow, actually there's a host of sessions tomorrow that you should not miss out, really. So we are going to start with two keynote talks. Just like today, we will start with two keynote talks. Mr. Chandan Bhar, he has 25 years of experience in big pharma R&D, and he's going to be talking about healthcare innovation in post-COVID era, and that is a very important topic, to show the way basically on how innovators should approach healthcare innovation. And then Dr. Himang Shah, IP head of Qualcomm, and he's going to talk about design thinking for innovation. So basically, Himang Shah, he's a mentor to many startups. He is giving talks across India to students. So he's a real, somebody you can reach out to, ask questions, and be part of the live interaction tomorrow. So again, I urge you to register either via free, link, or with a paid link to attend Himang Shah's talk, because we will send out the links only via email. So if you want, you have to register. And if you don't know how to register, or if you have any questions, I am going to give you one email address where you can write and So here, so Mansi at turnium.co.in, you can write to her. She's taking care of all the marketing folks. So you are all here because of her efforts, and she's going to respond to you in real time. And if you have any problems with the links, if you are not able to find a link, or if you want to know more, then please write to Mansi at turnip.co.in. So okay, let me show you more about tomorrow's sessions. And then in the live expos, we have ITTO. Okay, and again, how to accelerate and research, how to accelerate your research to commercialization. So folks, ITTO people, they are experts in this, innovation to market, uh, in the technology to business, basically. So as inventors, a lot of people don't have an idea. So I suggest that you really interact with them, and get your queries answered, reach out to them, because they are now supporting startups across India. So no holds barred, just network. So conferences are, this is the one of the things that conferences do, and we would like you to use that. Lexorb will have a session tomorrow. So one of India's leading law firms, so they are going to talk about the pitfalls in Indian patent filing. So they are very like experts in patent filing and prosecution in India. So everything you need to know, not just for filing, but even what happens after filing, how it goes, what are the variations you might land up in. So these are some of the topics for tomorrow. And again, I think many of you attended Shuchi Agarrwal's session today. It was such a great session. It was incredible how precisely she knows about laws and the details about academic inventors, licenses, and so on. So she will be in a panel discussion with Miss Mansi Chaudhary. If you know, Miss Mansi Chaudhary also took a pre-event session for patent agent exam. So again, I am looking forward to boosting IP filing in academia. Actually, I myself will be the moderator. So I am really looking forward to interacting with the two leading patent attorneys in India to talk about this important topic on IP filing. And again, Ms. Shuchi Agarrwal will be in a stream. So you need full access to attend her third session, which is hits and misses on the IP playground, which is going to be no theory whatsoever. She's going to talk with experience on things that would really be insightful for young innovators to really know what the real world looks like in terms of IP commercialization. Shravani and Yashashwani, again, they will be on day 2 with deep dive into copyrights. Again, this is a sequence, folks. So don't miss it today. Don't miss it tomorrow. 3 to 4 p.m. today and 3 to 4 p.m. tomorrow. So I suggest, if you are still thinking whether to register or not, go for it. Even if you attend, few just these 2 sessions, I can tell you the amount of precious time that these girls are going to have in terms of the knowledge they will give on copyrights. And then Miss Rima Saini, whose comment I think okay, it's not still there. She will take a session on key insights in academic technology transfer. Again, on this topic, which is actually the key theme of this Turnip Innovation Festival. We are focusing on boosting IP filing. So because innovation is a need of the hour, right? We are. This is the vision from which this innovation festival is being conducted. That innovation is the need of the hour, and there are hundreds of different ways in which government is having a lot of these funding and support. So there's a lot of things out there which people don't know. So get help where it's possible, and innovation will really lead to economic growth. So, and finally, we will have a session by Dr. Prachi Pandey. Again, she is India's #1 academician in IPR. So she is a IPR coordinator and associate professor in Bavaria Institute of Technology, BITS campus in Vadodara. And she already took a pre-event where more than 600 people, benefited from just the different types of patents that she discussed. And she will talk about patentability criteria. So many people are, not aware of the patentability criteria. So, and with the context, it will be a live Q&A where there'll be most of the time it will be talking, not and answering comments, not much theory. So 15 minutes of patentability criteria, and then you can feel free to ask your questions. So folks, that is it. I mean, so I see 2 comments. Yes, Rima Saini, she's here. She's here. Yes. So starting at 2 p.m.
So we are already at 1:38. So starting in 22 minutes, we have two sessions. I will put them in the background. So we have one session by Questel Orbit, Questel India. Mm, which I'll put it, and we have one session by Mr. Tapan Brahma on secrets of claim writing. So don't miss out, really don't miss out. And if you have any questions, I'm in the background. Feel free to write to me, and I will answer them.
Okay. Okay, Sukhvinder Sharma, thank you so much. Yeah, I'm actually juggling between streams. That's why this is happening. So yeah, I was saying that there are two sessions coming up at 2 p.m. One is by Questel India on realizing business potential for your idea and doing patent prior art search. So Questel is the global leader in patent search, folks. So don't miss out on their session. It's free. It's available as a live expo. But it's not this stream. It's a separate stream. The link to that stream is actually given in the chat. So if you just see the comment by Turnip, you can just click on that link to join that. So it's not the same as this one. If you want all the links to come to you, then I suggest that you register. So either you register for the paid or you register for the free. Either ways, you have to register so that the links come in your email, because we have separate links for separate sessions. And the other session that is starting at 2 p.m., which is private session, so it is available with full access, is by Mr. Tapan Brahma, Secrets of Claim Writing. Again, make use of that session, folks, because the knowledge you will get from that session is going to be so precise and so insightful, and because claims are such an important part of a patent. So as I was saying, if you register now for the full access, it is still possible. Immediately you will get a confirmation email that will have all the emails. So don't be worried that if you register now, whether you get the links or not in time, but you will immediately, within like a minute of registering, you will get the link. So there's a payment gateway link, which is a Razorpay link in the description of this YouTube video. Feel free, and you will get all the links for today, all the links for tomorrow, and then you don't have to go to separate places for separate links. So we are just 5 minutes into the sessions. So I will say goodbye to you in like 2 or 3 minutes. Unless you have any questions, you can ask here in the chat if about Turnip Innovation Festival or the next events and so on. And unless not, then I will end the session in like 2 minutes to have you go to the other sessions.